a lot of content. So what I thought that we have to make clear tonight is the reason why we do things the way that we do it. So you'll see that when you open a module, it also always says to you the following knowledge that you should have with regard to the module. So I know that there were certain people that was complaining that it seems like I'm reading the documents to you. It's important that you do take note of the content of certain of the material that was given to you. It does not exclude from the case law that you have to read. So the alternative and the additional material that is prescribed, you must also have regard to. So you must refer to that also while I'm talking. The other thing as well is it's difficult for me to explain to you as to what is happening, because I see that a lot of you, if I start talking from experience, you want to know on which page I am. That makes it difficult because usually in practice, I really get carried away because of what we do in practice, and it doesn't always correlate to the page where I'm at. So those are the two things, and that's why with every session that we've done, I go through the instructions as to what you should be able to learn from the module. And then obviously, if you do the assignments that's attached to the module, you get the drafting skill that is actually then requested or required from you once you approach this exam. So you'll see there's also a few of the notes that has been written by the writer of the notes to say that you have to prepare with the adequate other reading materials also in hand. But you are also welcome, like I've always say, if there's something that you don't understand, please put it in the chat box. And as and when I go through the notes, please ask me. With tonight's modules, however, it's really all relating to deeds office registration. So these documents that we're going to be discussing, the notary is a part and parcel of what we are doing. You have to register those documents in the deeds office. So it becomes important that the practicalities of registration is understood. And that is then the problem that I most likely will have, because I don't have a whiteboard to actually draft for you as to what we will see, so that it makes more of an impression. So please bear with me in the explanation of the things that we're going through, that you understand the knowledge that you should have, the definitions that you should have. And then we do try and highlight the things that we know that is easy questions, or that you can actually easily draft those things. And that's why I usually say, if you know the top part of the document or the bottom part of it, doesn't matter what we call it, but those are the things that get you an easy mark or so in the exams. And that's why I will say to you, listen, look at the preamble to this, or look at to the closure of this document, all important with regard to drafting. Unfortunately, we do not have the time that I cannot teach you how to draft. That's something that we do in practice. Um, yes, Kim, it is mainly with regard to drafting. However, we do try and teach you the principle, and that's what makes it so difficult, is that we try and teach you principle and try and bring that in accordance with what we do in practice, so that you can actually, in the end, not only draft, but have your documents registered in the deeds registry. And that's ultimate the question that arises. Have I actually told you enough so that you, one, know the content, and secondly, are you able to draft? I cannot teach you to draft in the sessions that we have, and therefore you need to know what is in here. Yes, Richard, I see that. No, I haven't heard any of sorts that you can take any of the books with you. All right. So important again, I'm just going to highlight again. Please, there is certain things, knowledge that you must gain. And then the drafting, as and when I say to you, listen, let's have a look at this, let's have a look at that. Those are the things that you must practice. The drafting you have to practice on your own. I cannot help you with that. What we'll also do tonight, with regard to some of these documents that we are going through, I am going to work from the assignments or from the annexes, just to give you a basic feel for what you should be drafting and how you should be drafting. And as always, when you get to deeds office practice, there is certain formalities that you have to adhere to. That's as easy as it gets. So if you comply with basic stuff, then at least you know when you get to the drafting that you can register your document, because in the end, doesn't matter how well you draft, if it's not deeds office compliant, you're not going to get to the target of your drafting skills, and that's ultimately having a document registered in the deeds office. So although it may seem very theoretically or theory against practice, you need to know the basis so that you can draft in accordance to meet the deeds office requirements. And unfortunately, tonight is one of those sessions where you need to have some basic knowledge of drafting and what happens in the deeds office when you want to register a matter. So without any further ado, let's start then with leases. Once again, when we get to these things, remember, please put in the chat box, and as and when I see that, I'll come back to your questions and then I'll answer them as I go. Otherwise, if we leave it to the end, I might not get to it. The modules doesn't seem so long, but they are very intense. The knowledge that you have to gain from tonight is really it's just a stimulus overload from beginning to end. So yes, so once again, so we get to leases tonight, and then once again, I am telling you what you should know. You have to be able to define. So when you go into your exam, they will ask you some definitions, and that's why we concentrate on definitions. You have to understand what happens when I refer to hier gaat voorkoop. List of formalities, because when you get to those type of questions where you have to draft, first and foremost, you need to know the formalities that's applicable to the document that you are drafting. And then you go to the essentials, what needs to be in the contract to be valid and binding in that lease agreement. The contents has to be in there. Some of them is more just general knowledge or general conditions that we have to bring forward into our documents. And then there's the requirements with regard to transfer duty, rates clearance certificates, stamp duty, that we have to understand how it fits into this greater scheme of things, deeds of hypothecation of leases and subleases. So the terminology becomes important as well. So you cannot draft if you don't understand the question. And then that becomes important as to what you make of the content of the notes that was given to you, because that sets it out for you. Then you also have to make or define the release of a portion of the leased land. You have to analyze the cancellation of a mortgage bond over a lease where a portion of the land is released from the land. Analyze the working of a lease with an option to purchase, and then list the general reasons for termination of a lease agreement. So these are the things that's really expected from you, and the knowledge that you have to gain from this. And remember, it's knowledge. I can show you what you should be drafting in your documents, but this is just for your foundation work so that you know where to start from when you are in your exam paper. And that's where we then go from. So for tonight's module 7 on leases, we start off with saying that previously, when you think of leases, there was a Rent Control Act, but that was repealed by the Rental Housing Act, or it's a Housing Act that came into being 1 August 2000. It does not apply or relate to notarial practice at all. So we have to be very clear as to what is included in this module. So we're not dealing with anything that relates to the Housing Act. We are dealing with long-term leases as such. Just the distinction, because that could be a catch for you as well. Once again, I'm referring to the definition. What is a lease agreement? It's a mutual contract between two people. The one promises undertakes to grant to another person temporary use and enjoyment of a thing, and the tenant in exchange for specific or specifiable consideration for it. Long-term lease is a period for not than 10 years, in other words, for more than 10 years, or for the natural life of a lessee, which is renewable from time to time at the will of the lessee indefinitely for periods, if you put them together, will be more than 10 years. Really important when you start thinking about a long-term lease. Remember, this is the foundation, what needs to go into your lease, and what they will ask you, how you distinguish a long-term lease from a short one, short-term lease. Right. Lesedi, let's just see any hands up for that one that you cannot hear. Anybody? Otherwise, you'll have to sort out your system on your side. Right. So that is for long-term leases. In other words, this is what we're going to be discussing tonight. Long-term lease, please keep in mind, period of 10 years or more than 10 years. So it's 10 years, 1 day for the natural life of a lessee, and it's renewable. So if we have a long-term lease where we calculate the amounts that we basically are leasing for, and it's longer than 10 years, it becomes a long-term lease that is registerable in the deeds office. Here, the notary is really important because they have to execute this document and register it in the deeds office to be enforceable against the lessor's creditors and successors in title. All right. So that's the ultimate goal of what we are doing tonight. You want to be able to register. That is like the outcome that you want when you're doing this lease or this module. Have a look at huurgehad verkoop, which means the successor is entitled to the owner of immovable property that remains bound by the lease agreement in respect of the said land for up to a period of 10 years, even if the successor in title has no knowledge of the lease. So we have to keep this in mind when we are drafting, whether we are selling the property, because if we sell it subject to a lease agreement, we need to know, if we see the clause, what does it mean? What is the risk involved for the parties entering into a new lease agreement as such, whether it will be subject to this clause or not. Then we get to the formalities in respect of leases of land. It's so important that section 1 is verbatimly quoted in your notes. Once again, this is something that you should really know. You shouldn't have any thought of, or give it a second thought as to what a lease is about. So safe and accept to say that it is longer than 10 years for the natural life of the lessee and renewable from time to time, with that period in making more than, or added up then make, or equals more than 10 years. Also, it is not invalid merely by reason of the fact that such a lease is not in writing. No lease of land which is entered in for a period of not less than 10 years, in other words, I give you the whole spiel of the long-term lease, the conditions that's applicable, and actually gives it character. So it will be valid against a creditor or successor under honoris title of the lessor for a period longer than 10 years after having been entered into, unless, in other words, it will not be valid, or you cannot enforce it against a third if it hasn't been registered against that title deeds of the leased land, or the aforesaid creditor or successor at the time of giving the credit or the entry into the transaction by which you obtained the lease did not know of the lease that was in place. So very specific instructions with regard to section 1 as to when is it valid or not, and why you should actually have this then registered. So we can have a lease agreement drafted, and if it's not a long-term one, remember, we don't have it registered. Then you have no problems, and it doesn't fall within the ambit of this module there. Then I also refer you to the Lease Act, Section 1.2, which is formalities in regard to the lease of contracts of land. You can have a look at it. Just remember, so a lease agreement is a bilateral agreement, and both the lessee and the lessor must be established. You must be sure as to who they are. Once again, as per previous modules, if the lessees are minors, they must be assisted by the parents, guardians, or parents might enter into the contract on behalf of a minor. If it's a company or association, or persons act as a lessee, the full names of the person acting on behalf of the company or association must be mentioned, together with a reference of the authority to act. Why is this important? Because when I register in the deeds office, this is the type of information that will be required. So important. So even in drafting our foundation document, which is our lease agreement, we need to keep in mind as to what the requirements at deeds office will be. Therefore, we have to have a look at the citation clauses that we did previously. So tonight, like I said, we are concentrating on what the deeds registry access because of the fact that one, the notary attests or executes the documents, and secondly, it is registered in the deeds office to the benefit of clients and actually has monetary value for them. You're creating certain rights for them. All right. So you can have a look at what section 3.1 there states as to the registration that is allowed in the deeds office, and the part that the notary then plays in this becomes really important because regulation 43 and 44 as per the deeds register is not applicable when we are dealing with notarial deeds that is registered. So there's no preparation clause or anything of the kind when we are drafting a notarial deed for registration in the deeds office. With regard to section 102, it's important that we know what is immovable property. Remember, we can only register immovable property in the deeds office. So you have to make sure that when you are giving advice, that the outcome that what you want falls within the ambit of immovable property. Are you registering a long-term lease? So there's two classes of leases that we are looking at. Any registered lease of rights to minerals and any registered lease of land that is longer than 10 years. And then you can see that it is from time to time or for the lifetime of that leasing that they are entering into. Such a lease will be referred to as a long lease, as we have seen in terms of section 3.1p, and it must be notarially executed before it can be registered. You cannot do the one without the other. The deeds office will definitely reject you if it hasn't been notarially executed. And that's a problem because of the set of skills that they actually think that the notary has, and that they should do their work much more diligently than anybody else in the legal profession. So it has to be notarially executed before it can be registered. What does Section 77 say with regard to this? Save where the provisions to the contrary is made by any law, any lease or sub-lease of a land, and they give you the rest of what is registered in the deeds office and how the notary should actually execute that document. So once important again is that the notary public will attest this document and that the document shall be registered for the full term thereof, included or including the periods of renewal. So your document has to make provision for all the requirements as per the Deeds Registries Act. So tonight we're going a bit further. So our original document that we have for a lease agreement does not have any format requirements. However, if you want it registered in the deeds office, we have to have a look as to what the requirements will be. They tell you as to what will happen in the case of a cession of a lease that is to be registered in respect of a portion of the land leased, and that the notarial copy of the lease shall be attached to such a cession, and after registration, such cession with a notarial certified copy of the lease annexed thereto shall be deemed to be the title to the portion of the lease so ceded. So important is that your lease that you initially drafted is attached then to your registration copy after the event. This is one of the exceptions to the rule. Remember, when you are dealing with normal transfer of property, deeds office do not see your offer to purchase. It's only the power of attorney and your deed of transfer that they get to see and examine. Whereas with this, you'll have proper documentation, founding as well as registered documents, and that is important if you want to see that specific registration or the right that you have created. Then subsection 2, if the land or right leased or subleased is mortgaged, now we're going one step further. Remember, all mortgage bonds as such needs to be registered in the deeds office. Now we are looking at the type of mortgage bond that we can register over a leased land or subleased mortgage property. So in this instance, once again, we have to define immovable property because those are the ones that can be registered. So we're creating certain rights that is deemed to be immovable property and therefore subject to a mortgage bond or possible that you can register a mortgage bond over those, and therefore we have to be careful that we adhere to the rights pertaining to the Deeds Registries Act. Also then have a look at section 78 and 2. If you're creating a deed by virtue of notarial attestation, remember you have to cancel it in the same fashion. So also you'll have to lodge it in a cover at Deeds Office, and you will have to make sure that your registration or cancellation is noted in the same fashion against the deed. Right? Julia, just check it on your side. We seem to have had a problem with Kim as well. Right. Section 79 then says that any lease of immovable property which is registered in the name of a lessee in a district may be registered in that registry, and any sublease or any lease so registered may be registered in that registry. This only means that if I have the main lease registered in Johannesburg Deeds Office, any sublease has to be registered in the same deeds registry as well. You cannot register the main lease, for instance, in Pretoria and the other one in Joburg. It does not work with that. The documents flow together, and they will most likely carry a WOP, which is a WOP endorsement, to say the one as or refers to the other. So this is just what Section 79 provides for. Section 80 as well, no cession of a lease shall be registered in any deeds registry unless the lease or sublease has been registered therein. So they start from the main lease, then the sublease, and then you can actually seat the lease as well. But all of those documents has to be filed and registered within the same deeds office. You can't just pick and choose any deeds registry in the country. You have to make sure as to where you are registering those and keep to the specific deeds office then. All right. Then section 81 deals with hypothecation of leases and subleases. So those leases, the hypothecation is effected by way of a mortgage bond. Listen carefully, over immovable property, but a notarial bond if the lease or sublease is not. In other words, if it's movable property. So we have to distinguish in which case we will be able to register a mortgage bond, and then the other instance is a notarial bond for purposes of registration in the Deeds Registries Act. All right. So we have to distinguish carefully when we get there. Then Section 82 provides for notarial bonds, hypothecating leases or subleases. So once again, this just deals with the formalities as to what we need to lodge in the deeds office for registration. What goes into my green or my blue cover in the deeds office when I'm actually lodging it, so that the registrar will register in the end. So I'm not dealing with what goes into your protocol at present or into the minute. It's all what we are registering or lodging with the deeds office for registration. All right. Those are the things that we have to keep in mind when we look at section 81. Then section 83, that is with regard to any law under a land settlement. If the lessee is given the option to purchase the property, lease any portion thereof, and he has exercised the option, the right to the property so acquired by the lessee may, if the lease is registered in a deeds registry and is not subject to an existing bond, be hypothecated by a notarial bond. All right. So this says that if you get the option to purchase, so what happens in deeds office is the following: we're registering a notarial or a property. Well, let's start with immovable property. So we work from fixed property. We register a bond thereover. But usually we do not transfer if there's any encumbrance of a property as yet. So we want to give a clean title to the next person that wants to encumber. So we want to give to that creditor or the person that's securing the finance, we want to give him security, and therefore you have to take care then of the existing encumbrance thereover. All right. It should then also be noted that in terms of regulation 45 of Deeds Registries Act, if one title has to be endorsed, the lease must be lodged in triplicate. All right, just a format requirement as to what needs to be lodged at the deed office. Then for your notarial practice part, an additional duplicate original. Remember, a duplicate is not a copy, it's a original signed document. Cross or certified copy must be lodged for each additional title deed and each lessee exceeding one. So in deeds office, what really happens is that we don't want a notarially certified document. We want something that was executed by the notary directly. That just makes for insurance that there's no fraud committed and that the people getting the rights is actually getting them without anything being fiddled with. Let's have a look at stamp duty. You remember stamp duty has been repealed in terms of the General Revenue Laws Amendment Act. Just make sure if there's any leases that's still in existence that was drawn but never endorsed, that they might have to get a stamp duty if you want to enforce the rights that somebody got under them. So always just make sure of the date when it was actually executed by the notary. That is the date. That's very important. Stamp duty in respect of leases, as I've just said, it was calculated in accordance with the tariff as prescribed by the Stamp Duties Act. So you can refer to that if there should be anything still arising from that date still. And then no transfer duty is payable on an ordinary lease of land. However, during the time stamp duty was applicable, then if the stamp duty have been exceeded or exceeded the value of the property, then transfer duty would have become payable and not stamp duty. So there's a slight differentiation um, between transfer duty and stamp duty as to in which instance it will become payable. Yeah, I don't think we see it that often in practice anymore, seeing that most leases that was executed has really come to an end at this stage. But there is always the exception to the rule, and that's why we always have to check the dates on these documents. Then a lease for a portion. So if the lease agreement is only in respect of a portion of the land registered, and remember once again, we are working with immovable property in the deeds office. So we're assuming that a portion of the land has been registered, or if it's registered at deeds office, that there was some other form of diagram with regard to the portion of the land issued. So we cannot just transfer and merely refer to a portion of the land because we think it's on the furthest side, corner, right-hand side, along the boundary wall. That is just not good enough. There needs to be a Surveyor General's approved diagram that is next to your lease or sublease. And you'll see when we get to servitudes, it really becomes important, the description on diagrams. We do not just want to lodge a document that loosely refers to a portion of property, because if we're dealing then with farmland, we'll have to get the minister's consent if it hasn't been delineated properly. And that's in where our problems arise from. So the following lease agreements may not be registered at deeds office. All right. And that's what I've just been saying to you. So in respect of a portion of a building, accept a lease agreement in respect of a sectional title unit. I'll get to that as well. What is the difference with the sectional title unit? There's a definite diagram stating where the property is situated, how we find it. You can clearly go and look for it and you'll find it on a diagram. So there is some other form of diagram attached to this. In respect of the whole land, with the exclusion of certain portions of the land. So you cannot register any deed where you cannot have a proper description of what you are registering at the deeds office. And then lastly, like I said, then Act 70 of 70 gets important because we cannot do this in respect of a portion of agricultural land. All right. However, if there is a portion that already is considered or has been, diagram has been issued for, in other words, it has been converted or it looks like immovable property, then it can be registered and you can actually register a bond over that. But that's just on the side. This is very important for the exceptions for the lease agreements that cannot be registered at deeds office. Should you try, the deeds office will reject them because these are not registrable documents. So very important, deeds office will make sure that you don't get registered. Then we get to agricultural land, and this is once again subdivision of agricultural land. You cannot subdivide anything that will constitute a subdivision of land, which is now agricultural land, cannot be subdivided without the written consent of the Minister of Agriculture. All right. So that is always a problem in obtaining that consent. So it's not impossible. It's just a matter that you really have to have a lot of resilience to obtain that consent. So yeah, also keep that in mind. That's usually one of the things that they attract in your exam is with regard to the subdivision or somewhere along the line of the subdivision of agricultural land. Either it has not been delineated um, or yeah, the description is not certain. Then we get land subject to a mortgage bond. Remember when you are registering property firstly, so we have property that's registered and we're creating certain rights for you. We are taking out a bond to finance some or other expense. Then it is um, important that we know the ranking of the bond that we are dealing with. A mortgage bond will have preference over a lease agreement. So although we are registering a lease agreement against a certain property, the mortgage bond will always have preference against the lease agreement that we are registering. So the exception to the rule, once again, is when we are selling a property in a sale and execution. Usually, then the sheriff will stand up and say, listen, we are selling this property. Um, can I get a bid for the property with a lease? And then usually there's nothing because people don't really want to buy property where there is already a lease registered over it or whether there's any leases, so to say, registered or in place. And then he will take that blanket off and he'll say, all right, then we're selling it without um, the mortgage or without the lease agreement in place. So those are some of the things that we have seen happens in practice when you are yeah, dealing with lease agreements. Then a registered long-term lease agreement may be hypothecated. In other words, I may register a mortgage bond over the lease. Why? Because that lease is considered to be part of immovable property. It is deemed to be that. And therefore, we can register a mortgage bond. So the difference is slight. It's a mortgage bond that we are registering over the lease. Unregistered long-term leases, in other words, your drafting skills really excelled, but you didn't get it ready for each office. And registered or unregistered short-term leases can be also hypothecated by means of registration of a notarial bond. So then you get a different ranking with a different type of bond, with a different type of or set of rules that you apply to that. So the main thing always to consider when we're working in deeds office, what are we working with? First, distinguish immovable, movable property. What type of bond is it? Is it mortgage bond or a notarial bond that you have to deal with, or what? Which is the one that they're actually asking questions on? Then the next thing that's important when we are dealing with leases, we're looking at usufruct, usus, and habitatio. So Section 66 of the Lease Registration Act is quite clear about this, that no personal servitude of usufruct, usus, or habitatio purporting to extend beyond the lifetime of a person in whose favor it's created shall be registered or transferred or ceded um, because it is a personal servitude. Once again, exceptions to the rule I've just said, usually it's immovable property. However, these personal servitudes are registrable at deeds office. However, you cannot register something that does not attach to the person anymore. It's a personal servitude for a reason. So it's clear that the personal servitude can also then be leased. If I can register it at deeds office, it has certain financial value. Remember, when we get to usufruct or usus or habitatio, usually there has to be some form of diagram setting out what it is that we are using or what is the servitude that we are creating. If we are leasing it, the lease, if it's a long-term lease, so you can do the same. It's for longer than 10 years. It's for the usufructuary's lifetime. And usually the combined time frames that we are entering into lease for falls within the long-term lease. Then we can register it against the title deed, binding on successors in title. And then clearly note, a usufructuary cannot give more rights than what they got. I can only give away to the extent what I have, not more than what was given to me. So you can register then a usufruct for longer than 20 years. But the problem is then if the person should be, if you should die before the expiry date, then the estate could be exposed to an action for damages. Of course, the usufruct will lapse on his death, and the full ownership will go back then to the bare dominium owner. And remember, this transaction in itself then attracts transfer duty payable in this matter. So one just have to be clear and try and see whether you are working with this usufruct, that you're registering it for what time of period. Remember, it's a personal servitude that you are registering when you are working with these things. So they do have economic value and therefore registrable. All right. However, economic value, when you're cancelling that, the value falls back to the bare dominium owner, and that's the reason why it then attracts the transfer duty. You'll have to have a look at the tax or the Transfer Duty Act as well, so that you know how it is worked out. Usually, it's worked on the value that was added or created. There's a whole thing that they work out around the value that actually then gets given back to the bare dominium owner. All right. They give you all types of solutions to the problem when you are selling or leasing this property. In other words, when you are the usufructuary, that they can join you as a lessor and that you can deal with the problem as such, assuming that your usufructuary is willing to do so. But yes, that I don't think is really the end of your problems should you add them as a lessor. If the land is subject to a personal servitude, the lease agreement will be subject to that personal servitude. All right. So the one thing is subject to the other. And then I'll get to the waivers that goes with the subject clause in this a bit later on. Then one of the things that is exceptions to the rule, we said on the previous page that lease agreements may not be registered in the deeds office. The exception to the rule is a lease agreement in respect of sectional titles. So sectional titles has its own set of rules. Also, it's immovable property that's registered. Difference between a portion of land and a sectional title, usually the diagrams. We can say clearly which property we are dealing with, how it is delineated on a diagram, and we give transfer to a person in time, in terms of the sectional scheme that was created by virtue of that sectional title scheme then. All right. And then they just make provision there as to how you actually work it down. If there's a lease registered against your sectional title, the sublease, and then the cession also has to be registered and endorsed against your title that was created in that title deed then, or sectional title. Then section 17.1, the owners may by unanimous resolution direct the body corporate on their behalf to alienate common property. So this is now the exception again. So remember, sectional titles, usually we have units and we have exclusive use areas. That is a definite that we can see on a diagram. But the common property is all the areas around the structures that has been put onto this property. So, but notwithstanding that provision, but subject to compliance with the provisions, any relevant law relating to the subdivision of land or letting of a part, as the case may be, have power to deal with a common property or part thereof in accordance with the direction and to execute any deed required for the purpose. So we look at common property, and then the body corporate is given certain powers to deal with this property that really has not been described. It's just described as the common property, and we can see it on a map. That is really what we can do. We can go look at the diagram as a map to see where the common property is situated, and then we may register or alienate it in the same way as registering a lease, a long-term lease for a part of that property. The exception to the rule again, and that's why sectional leases becomes a problem, because you have a division, you have to have a look as to who has the authority to deal with the common property on behalf of the sectional scheme, where's your authority, and you as the notary in this instance will have the obligation to ascertain yourself as to the powers of the body corporate and or the managing agents, because in a lot of these instances, the managing agents have a mandate to act on behalf of the body corporate, and then you have to execute a document with regard to this lease that you want to register. So you have to make sure who has capacity to mandate you to act on their behalf and then execute a deed on their behalf in the deeds office. So this becomes very important, that you are able to register a deed with regard to this. Also, a copy of the relevant resolution will be necessary and certified by the trustees of the body corporate. Those are things that one has to have a look at as to the requirements when you are drafting the documents, because your citation then also then becomes important as to how you will cite the trustees acting on behalf of the body corporate. All right. Then section 17.4, where pursuant to the provisions of subsection 1 of the Act, it is sought to let a portion of the common property on which a section or part of this section is erected. The register shall not register a lease unless the registration of the section in question has been cancelled with the written consent of the owner. Once again, it has to do with the encumbering of a property. We don't want to carry over ownership or give that right to immovable property or even that personal servitude if it is not a clean right, if you think of it in that fashion. So we'll have to cancel the unit first, and thereafter we will be able, so you will cancel the registration of the unit, it will fall back within the common property, and thereafter you will then register that portion of the common property under the notarial lease. That is just a bit of formalities that you have to go through to have that registered also in the deeds office. Then we look at contractual requirements. So remember always the foundation of notarial deeds. You have to comply with certain contractual requirements. One, competency, I cannot describe it. We've just had a look at sectional titles. What is the authority for a body corporate to act? And the notary must satisfy himself that the memorandum and articles of association or constitution, as the case must be, give the body corporate the right to enter into a lease. So we always have to check the mandate. You cannot, or the authority. If the authority has not been given, then they cannot enter into the lease. So representative capacity, again, when you're dealing with companies, close corporations, also, you keep a copy of that relevant resolution where the company or the the close corporation, sorry guys, gives authority or a resolution for somebody to act or sign documents on their behalf. Very important. Those type of documents goes into your minute as well. So you have to keep that as well for your records to make sure that you had the necessary authority to execute the documents. Then the parties must have sufficient title to the property. A lessor cannot validly grant greater rights than the ones that he has himself. So if I was granted certain rights in terms of usufruct, I can only cede that personal right in the same fashion or to the same extent as to what my rights extended to. Then once again, the provisions of the Matrimonial Property Act becomes important. The citation of the parties with regard to the parties usually when we are buying and selling property becomes important with leases as well, and long-term leases specifically because of the fact that we want to register. Therefore, we have to comply with the Act. All right. So the drafting they refer to for you to example 5.1 and 5.2. I'm going to skip on paragraph 11.3 for you because if you turn the page, it states nicely as to the subject matter of leases that we are going to just quickly run through. So remember, when we are dealing with the long-term lease, usually we comply from the word go with the conditions or the compliancing necessary to effect registration in the Deeds Registries Act. So once again, it doesn't help you drafting and you cannot comply. The effect of non-registration would be that your agreement will only be effective between parties and not against thirds. Would be really defying the purpose of registering a lease. So the subject matter, what should be in a lease? So one, it should be legally, or well, it should be legal and it should be physically possible. So we start off usually with the full names of the parties. We need to know who is the lessor and the lessee. The lease, so the landlord usually, well, he can be the registered owner depending on the situation of the land. Then the description of the property that we are letting. Remember, deeds registry's description and citation then in this instance is required. The land as well, if we are dealing with a usufruct, then it will be the division between the description of the property that we are letting, which would be in the case of the usufructory, maybe the granny flat, for instance, that we are letting, but the land may be in the name of the bedominium owner. So there's the distinction between the description of the property that we leasing and the land. The period of the lease and whether there's an option to renew. Remember, when we're dealing with long term, it has to be longer than 10 years, or the combined period has to be longer than the 10 years. The use and enjoyment of the matter accrue to the lessee temporarily. Um, and then your lease may run from one fixed date to another. In other words, can be from 1 March this year to 28 February next, or it can be from the 1st of March this year for the next, although you have to have a 10-year period in between. So if it's from the 1st of March 2022 until the 28th, no, I'll make it the 1st of March 2032, so that we have 10 years and 1 day, so that it's a long lease, and therefore it's registrable against the property that we are leasing. A further lease to the agreement can be registered, whereby it's agreed that the said lease will only become operative once the initial registered lease lapses by a fraction of time or for any other reason. So we can have that other lease lurking in the background, waiting for the one to basically expire. That is part of the conditions that you may put in your contract. Then you have to have in a rental and how it's payable. The remuneration for the lease must be payable in money. However, rural property, you are allowed to pay certain of the rental in fruits of the subject of the lease. The purchase for which the property to be let and whether there are any restrictions on the use of property. This becomes important then when we are dealing with farmland or a portion thereof as to what is the nature and what is it used for. Then you'll have to really describe it, and then usually you have to look at law providing for certain conditions as well. So the purpose then and the restrictions becomes important to keep in mind. Then the insurance of the buildings becomes important. Who's paying for those premiums to make sure that should it burn down, what happens to that long-term lease? The cession of the policies to the lessor and the right in his favor to pay the premium. if the lessee should fail to do so and recover it from the lessor then at a later stage. So usually insurance is something that they put in because of the fact that life happens and that we want to make sure that we have something valid um, and that lasts or outlasts really the time of the lease. Then the conditions of the lease agreement, and obviously we will go through the general conditions pertaining to a lease agreement that goes into a long term. And then there's no rules regarding the conditions that should be included in the lease, save for the subject matter that really determines that it's a long-term lease. For the rest, yes, you have to have the parties and the essentials that I've just run through. But for the rest, you can add conditions as per the circumstances of your agreement, i.e., it can be for the maintenance that you can add onto that, compensation for improvements that you have done to the property, depending on how you structure the contract. Then just take note that since your leaser has a tacit hypothec for a rear rental over movables brought onto the premises, it is advisable that you must state also that the lessee shall not dispose of such movables without consent of the lessor, otherwise than in the ordinary course of his business. So those are the clauses depending on your type of lease that one must take or give consideration to at least, whether they may buy and sell if it's during the course of the enhancement of their business. Then have a look at the payment of rates and taxes that's usually undertaken by the lessor. In other words, I move into your property, but who pays those expenses? Otherwise, just now I am out of lights and or water. Well, not really the water so much, but the electricity will definitely be a problem if I don't pay it. Then the provision that the lessee shall not have the right to cede or assign the lease or sublet, which consent they shall not unreasonably withhold, must be included in the lease agreement. So this is one of the things that you can really also include in it, just to make it safe for everybody, that you don't have subleases that you are not aware of, or that your landlord is not, or owner is not aware of. Then with regard to farm properties, as I said, you'll have to investigate to see what is the capacity, what needs to happen with regard to the removal of the growing trees, making new lands, burning veld, or the limitation of livestock according to the carrying capacity of the veld. So, yeah, when you are dealing with farmland and leases thereof, you'll have to have a look at the act that is determining at that stage with regard to the water supply, environmental conservation, and so forth. Then just have a look as well. Remember, a long-term lease is also then registered, when we think of mineral rights. So that's one of the things that we can also then register as a long-term lease. Stone, sand, clay, and rock was not traditionally regarded as minerals, but those have changed. So these days you can register a long lease over these if those are the minerals that we have found on the property and they are still available for leasing. Then also you can determine in your lease who will be paying the cost for the lease, or stamp duty if it was applicable previously. Then what happens in the case of breach if any of the parties do not comply? And then as the legislation changes, obviously the requirements for the content of your lease will then also change. Then you'll have to have a look to that condition or the example that they refer to in Law 1987 on 303. Right. Obviously, always bearing in mind when drafting, the description and status of the parties is very important, because we are going to register a deeds office. You have to comply with those things. As previously stated, termination of lease agreements. When do they terminate? 1, termination is expiry of the lease period, or if there's an occurrence of a specific event as determined by the lease agreement. In other words, we have a fixed term or it is for 10 years from now and that has now transpired, then obviously that is a termination clause that we can bring forth, depending on what our client's instructions in this regard may be. However, remember, on termination, a notarial deed created has to be terminated by virtue of a notarially executed deed as well, and you register that deed at deeds office. Remember, if you don't register your cancellation or the termination, then the notarial lease will stand as it is because it's not dealt with. Just have a look at the death of either the lessor or a lessee. That will not necessarily result in the termination of the lease unless you have agreed to the contrary in the termination or in the lease agreement that you have done. Have a look at Section 37 of the Insolvency Act. Parties cannot provide that in a lease agreement that the lease will terminate in case of sequestration or insolvency, and such provision will be null and void. Remember when we dealt with Insolvency Act previously, when we did wills last week, you could say, I don't want to inherit because of a pending insolvency or the fear of that. In this instance, unfortunately, if you cannot make the statement in a lease agreement that it will not, that the lease will terminate to safeguard assets in this instance. Obviously, termination as well will be because of destruction of property. And then the registrar deeds office, where deeds office is registered, will, on written application, accompanied by an affidavit by the lessor, cancel the registration of the lease if the lease makes provision for the cancellation of the lease agreement due to the default by the lessee. So it's important when we are drafting and we get into that default clause that we make specific mention as to how it will happen. What will the one party have to do to effect a cancellation in the deeds office? Otherwise, a registrar will not likely adhere to a cancellation if good cause had not been shown that there was actual default. If the lessee takes transfer of the property, obviously then your notarial lease will lapse by virtue of a merger. It must be cancelled, like I said, and then there's procedures that need to be followed as to the notarial deed that needs to be drafted, and then all the conditions or the provisions that one has to include if you want to allege that somebody has defaulted on their payments that needed to be made in terms of your agreement. Just have a look at it as to the notices that has to be given. Yeah. And then if there was a mortgagee, remember, this is a right that was registerable at the deeds office. Therefore, I could have taken out a mortgage bond or a notarial bond, depending on the instance. If there is a mortgagee for either of those, then the mortgagee will have to be notified if the lease will be cancelled. And then you must either decide whether you're going to cancel the mortgage bond or whether you'll just release from the operation of the bond. Just keep those things in mind with regard to termination and registration of your long-term lease. All right. Any questions with regard to your long-term lease? Anybody? Do you all want a 5-minute break and we'll be back by 20 to 7? How does that sound?
Yes.
Is that all right with you? All right. 20 to 7, guys. 1840. All right, everybody. I hope that you have recharged a bit, but let's get cracking. Yes. So just to recap on leases, although it just says leases, remember we're dealing with long-term leases, longer than 10 years for the lifetime of the lessee, as well as those time frames or periods when added up is more than 10 years. Long-term leases. So although we're just referring to leases for your module chapter heading, it is long-term leases. So on the next round, now we are busy with notarial bonds. So notarial bonds is usually the problem that we have because they really take some drafting skills. You'll see as we continue with this, there's a lot of definitions within that, and then the examples or the correlation between the difference or the differences that we get makes or break your type of bond really that you are drafting or not. So just to start off with, page 187 gives you a nice comparison between the different types of bonds that you can register, the definitions that goes with it, as well as the legal exceptions, and then the causa that you will use in your bond um, for your deeds office registry purposes. And this is where, if you know the detail of this, especially the causa that goes with the different bonds, that is easy marks because, yeah, if you know the type of bond and the causa that's required, you can go a far way when you are starting the drafting because that sets the whole scene for what is to come in your bond. Um, so, yeah. So, page 187, I think, for purposes of tonight's lecture, really, really important. But for the rest of it, we're going to go through the definitions again, see what is a pledge and how it differs from what we are busy with and how does it fit into the scheme of a notarial bond. And remember, once again, outcome of this module is that you have to have the knowledge, you have to have the drafting skill, and it has to be registrable. Otherwise, it has no purpose. And remember, you're securing debt in this instance. You really don't want to be liable for something where you should have made provision for somebody's benefit or the recovery of debt, and you haven't done so properly because you haven't registered or it was not registrable, the document that you have drafted. So once again, we're looking at the definitions. You'll see for a notarial mortgage bond, a pledge, who is a mortgagor, what is a mortgagee, distinction there, what is a general and a special a notarial mortgage bond, what is the requirements for notarial bond, causes of indebtedness. Remember, the causa is really important when we do this. Memorize this, please, guys. This is just on the side. What is the content that should go into it? What does Section 80 of the Administration of Estate Acts actually mean? What is the content of a notarial mortgage bond? Uh, the various descriptions or the different types of bonds that you can get. How will you cancel a notarial bond? What is the procedure to do so? How do we release a property or person from the working of a notarial bond? Um, how does the working of a part payment or the noting of a reduction on cover happen? In other words, where do we note it? What does it mean? What is a waiver of preference with regard to a notarial mortgage bond? Can we substitute the mortgagor in respect of a notarial bond? Remember, this will have reference to a normal mortgage bond where we can actually substitute. Analyze the sessions that we can do for notarial bonds. What is the type of sessions that's applicable? Understand the noting of a variation in terms of the notarial bond. What conditions may not be varied? Which ones we can? What is the application of the National Credit Act to notarial bonds? List the category of credit agreements referred to in the Act. What is excluded from the scope of the National Credit Act? What is the consequences of an unlawful agreement? and then what is a common law remedy that is available to your consumer and which may be waived or used in your credit agreement. Remember, because when we analyze a notarial bond, we're looking at a credit agreement now. And what is the application of that? And then analyze suretyships with regard to the National Credit Act. All right, so a mouthful once again, lots of information. Yeah, if there's any questions, really, you are welcome to ask. I know that time is limited, but I'd like to answer questions as I go because this is really something I love working with notarial leases and bonds, especially registration deeds office. Yeah, so if there's any questions, please do not hesitate. I'll answer as and when the question arises. So yes, so we get definitions. So what is a bond? So we must first just understand the working of a bond. So a bond we use to secure an obligation in the part of a debtor towards a creditor to ensure the repayment of a money lent to the debtor by the creditor. All right. So there's some form of indebtedness that we are dealing with when we are registering a bond. In terms of Section 102 of the Deeds Registry Act, and remember this is important because we want to register that bond. Now we're looking specifically at the notarial bond. It means that bond attested by a notary public hypothecating movable properties generally and specially. All right. This is what we are doing with a notarial bond. So a notarial bond can then, in terms of this description, um, either be a general or special one, and they are registered usually over movable property of a mortgagor, and they are registered by the Registrar of Deeds in the appropriate deeds registry's office. All right, so those 3 points really important when we get to bonds and notarial bonds that need to be registered. So for purposes, understand what is a bond and what is a a notarial bond, and the two types of notarial bonds that we can get. Then they make mention of the registration. There's certain procedure that we have to follow in terms of the Act, specifically Section 61 and 62. Very important if you want to register your notarial bond. Once again, we look at the preamble of the registration or when we get to a notarial bond. And in this instance, I really want to have you page 192 with regard to notarial deed of lease. That's important because if you have that preamble down, then you can already go a far way in this. Once again, if you are on page 192, you'll see that they make mention commence in the middle of the page. Remember, with all notarial documents, format pre-required as per deeds office that you start in the middle with all of the fancy stuff that you have there, your protocol number, depending on where you are in your protocol. The heading is important, and then comes what we need to see. Known to all men, it may concern. So it's the date that is important before the notary with the LPC number. Notary public, remember we have to state the address, the province where they are practicing, and in the presence of the subscribing witnesses personally came and appeared. So that is our preamble that really creates or sets the basis for the start of any of our notarial deeds to be registered in a deeds office. So I think if you can memorize, train it, draft it, then this is one of the good starting points when you get to notarial bonds that needs to be registered. Then having regard to section 61.1, every notarial bond must be registered within 3 months after the date of execution or on such period as the court may on application allow. Remember, 3 months is calculated exclusive of the first day and inclusive of the last day. So you'll see where the notary gets involved, there's usually time frames applicable for registration, for valid registration. You really have to have a look at that. Every bond must be registered within 3 months after its execution. Remember, that's when the notary puts the signature to this. So your preamble, the day on which they came and appeared, then becomes really important that those spaces are not left blank, because that determines your 3 months after date of execution, not registration, of execution. And the calculation of that 3 month period is then set out there as per the reference conference resolution. If this deed needs to be registered in more than one registry, you take your documents. It has to be registered in the first deed registry, then within the 3 months period from date of attestation before the notary. And then in the second deed registry, remember, we're still busy with execution, not registration, attestation before a notary. And then when you move on to the second deed registry within 1 month after expiry of the initial 3 months, obviously if you can do that sooner, it's all fine and well. And in every subsequent deeds registry thereafter within a period of 1 month. So time frames very important, so that it's one executed by the notary and secondly registered within the time frames as specified by the Deeds Registries Act. All right. So you can see section 61, the place and date on which it was executed, and the place where the notary practice is important. It sets that out. Then it's important the place where the debtor resides, and the place or places, if any, where he carries on business. All right. So that's the registries, the way we will register this notarial deed. So important that when we get the information, that we register in those deed registries applicable to the transaction or where we are at. All right. Then, as I said, section 62 then carries on with that as to what will happen. The exception to the rule is, however, bonds or notarial bonds registered in Natal. It doesn't really matter, irrespective of whether debtor resides or carries on business in Natal, they register at the deeds registry in Maritzburg. So when we get to notarial bonds from Natal, doesn't really matter what happens to the rest, whether it resides, carries on business in Natal, it will be sufficiently registered for the purpose of the Act if registered in the deeds registry at Maritzburg, exception to the rule. And then the registration of a notarial bond in accordance with subsection 1, effective as registration for the whole of the Republic. So if I do a deed search in Cape Town and it was registered in Bloemfontein, I will see that there was a notarial deed executed. All right, so that's something that we can do. The registration of the notarial bond in the deed register for every area in which the debtor resides or carries on business shall be effective for such area. So usually, although the first one says it's valid for the whole of the Republic, we make sure that all deeds registries takes note of this notation as such. And therefore we register then in each and every registry where they're either doing business or residing. So that is just in practice how it happens. Then if you look at subsection 5, a notarial bond which is required to be registered in more than one deed registry, you have to comply with subsection 1 of section 61 for the second registry within the additional period of 1 month, and each successive registry within a further period of 1 month thereafter. So this is what the Act says, and we have to comply with that registration procedure. All right. Then you'll see what the documents is that is required in this instance. If you're registering in other registries, what you'll take is that duplicate, or remember, a duplicate is not a copy, it's a duplicate original. In other words, when you get clients to sign, you make sure that they sign more than one set of documents originally, so that you have a duplicate original that you can lodge in another deed registry. All right, just have a look thereof. Remember, the gross is important for your minute, and then obviously in your protocol it gets numbered as when you are executing documents. All right. So yeah. So this just again, section 62 then says that the notarial bond must be registered in the area in which the debtor resides, and then registered in these registries for every area where he resides or where he carries on business. Okay. When it's a company, registered office of that company is then where that gets registered. All right, guys. Is there anybody that's not muted? The secretary. Paul, can I please ask you to mute yourself? All right. Thank you. In Sibongile, in every registry. So we will take it as per subsection 6, and then you will register in each and other deeds registry. So then we follow that 3 months after attestation, and thereafter the 1 month and the 1 month that we do in each other or in the other deeds registries where they are doing business. All right. So we follow the act in these instances. All right. All right. So they usually say that a certified copy of the notarial bond is acceptable for the deeds registry in instances where it's necessary to simultaneously register the notarial bond in different deeds registries. So if there's something that needs to happen at the same time, then a certified copy of the notarial bond is acceptable. But once again, we do suggest that you get that duplicate original sign when you actually are registering or when you are lodging, so that you don't have a problem with the simultaneous registration of your documentation. All right. And then they also say that the registration for the notarial bond in the second and other deeds registries will be the same then as the date of registration in the first deeds registry. Obviously, if it's a simultaneous one, it speaks for itself that it will happen at the same time as well. Usually, in deeds office, just a practicality is that you'll go to the registrar and you'll say to him, listen, sir, I have a notarial bond in the deeds office of Bloemfontein that's also registering today, and you will give them a call and Bloemfontein to say to them, do you have this matter on prep for registration? And if so, we confirm registration will happen today. So practical in the deeds office, that is how you get registration happening from here to Cape Town on the same day. Then we look at mortgage bonds and notarial bonds, just so that you can see the different ones that you get in them. Then the general mortgage bond. So section 50 then of these registries acts becomes important. Just that they say a mortgage bond or a notarial bond may be registered to secure an existing debt or a future debt or both and future debts. So that's the purpose of the registration and what you may do in these registry. Mortgage bonds or notarial bonds intended to secure loans for building purposes shall be deemed to be bonds to secure existing debts. When this gets important is when we get to the causa for description as to what is the cause of the registration of your bond in the different bonds that we are getting or that I'm getting to. If a mortgage bond or notarial bond purporting a secure a future debt, the amount of the existing debt is mentioned, and then such existing debt shall be deemed to be secured as part of a maximum amount intended to be registered as a bond. And so that is with regard to mortgage bonds for a future debt that we are registering. Section 51, just have a look with regard to no mortgage bond or notarial bond attested or registered after the commencement of this act shall be of any force of effect for the purpose of giving preference or priority in respect of any debt incurred after registration of such bond, unless it is expressly stipulated in the bond that the bond is intended to secure future debts, generally or some particular future debt description therein, and then that the sum is fixed in the bond as an amount beyond which future debts shall not be secured by the bond. All right. So this subsection or section 51 then deals with future debts that we are securing in terms of our bonds, not necessarily for debts that was already incurred as per our ordinary bonds. Yeah. All right, the same thing goes for section 52, 54, and 55, which actually says how the cession of a mortgage bond with regard to secure future advances may be registered, and then how that will actually then rank, or how you will actually then reduce that amount of the bonds. All right. A bond can be passed by more than one mortgagor, but no release from the bond without the written consent of the one to the other. So if I register a bond by two mortgagors and I want to cancel or release, I need both of their signatures. All right. It's not a matter that we pick and choose. If it is two mortgagors have to give their written consent with regard to the cancellation or registration. Of all the property of any mortgagor may be registered unless such mortgagor is released. So if there's one or more and we're securing the future debt, then it is assumed that we're using all of the property for that purpose then. All right. Then we get to the classification of notarial bonds, all right, which is really important. So a special bond is regarded as one where there is specific property bonded, and a general one is where all the property of a mortgagor is bonded. Then we also get to, so within this, so it's usually either a special or a general notarial bond. And then we get to the different bonds that we can register at the deeds office. The first one is an ordinary bond, which is used to secure all existing obligations. All right. As security for due fulfillment of the debtor's existing obligations, movable property in general or special movables, as specified in the bond, can be hypothecated hereunder. That's an ordinary bond. That's the easy one. That is for all our existing obligations. Then we get to the covering bond, which are used to secure present or existing or future obligations, or present or existing as well as future obligations. All right. So the covering bond is a different one. So because your security is a fluctuating debt, it's something that's not stable and has to be determined from time to time. So what we usually see in practice is that if there's a defaulting party, that we have to get a certificate of balance so that we could say at that specific time what the debt was that was incurred because of the fluctuation level of debt. So a covering bond in its pure form is a bond that is registered to secure debt or obligations that did not exist at the time when the bond was registered. So say, for instance, I'm buying a property, and in order to finance this deal, we take out a bond to do so, then that would be for, well, it won't be for something that's existing. The future debt will only be incurred after date of registration. So Section 51(1) stipulates only two requirements which notarial covering bonds has to comply with for such bond to have any force or effect or affording any creditor preference or priority with respect to any debt incurred after registration of bond. All right. It is actually a provision for continuing covering in security, and then you can convert your original or your ordinary bond to a covering one. And remember, we're still busy with notarial bonds in this. And then you have to always remember, if you want to change the type of bond or security that you are using, the cause of debt clause and the insertion of a continuing covering security clause must be kept track of. Otherwise, there is no change in the conditions of that ordinary bond. So I see a lot of people in practice creating an ordinary bond, then your client's needs change and you just want to change it to a covering bond, and then they forget certain of the provisions, and then you're still stuck with an ordinary bond because you haven't inserted that continuing covering security clause. The additional amounts that you state in that cost clause will not be considered as a future debt. So that is something that we see as a matter of course, is that you'll secure the debt for 500,000 together with an additional amount of 100,000. That does not form part of any future debt. That basically deals with expenses incurred and as such does not equal future debt. Then we get to collateral bonds as well. So what is a collateral bond? So there's already a bond registered at the deeds office, and you want to have additional security or collateral for a bond that has already been registered in the deeds office. You can either do it after the bond, the ordinary or your covering bond has been registered, or you can actually do that simultaneously at the deeds office. However, if it is a different mortgagee to your first one, you'll have to get consent for that simultaneous registration because it has an impact on the ranking and the when we get to execution, then they lose value in the bond. So it is important to note that a collateral bond is a bond passed by the same mortgagor and the mortgagee in this principal bond for the same debt or obligation that has been secured in the principal bond over other movable property belonging to the mortgagor as additional security. So the only difference here is that there is other movable property that we are using as collateral or additional security for an existing bond. All right, that is a collateral bond. The collateral bond may not be for a sum exceeding the sum which existing bond makes provision for already. So if I have a bond for 150,000 registered, then my collateral bond cannot be more than the 150,000 that we already have registered. Like I previously said, you can register the collateral bond simultaneously with your principal bond or even after the first one has been registered, depending on your circumstances. And then once again, collateral bonds have to be drafted. There's a certain form KK in the regulations to the Deeds Registers Act that you have to follow. So this is actually a rejection note. If you don't comply with the format as prescribed, then they reject your deed, and as such, it does not register in the deeds office. So one must just be sure as to your drafting that it actually complies with Form KK of the Act. Then we get to a notarial surety bond. So this is registered by a third party. So in all of the previous bonds, we had the same mortgagor and the mortgagee as in the principal bond. But when we get to a surety bond, this is a third party that provides security for debt or obligation of someone else, a principal debtor. So we'll give a further additional security of somebody else's property then. A notarial surety bond can be described as a third party that's giving surety over his own movable property on behalf of the principal debtor in favor of a creditor of the principal debtor to provide security for the obligation of the principal debtor towards the creditor. All right. The surety usually bounds himself for a smaller sum, not a greater one. Then you get two types of notarial security bonds. Then you get the one that is actually providing security for a bond that is already secured, all right, by a registered mortgage bond. And then the other one is basically by a third party in respect of unsecured debt or obligation of another. And for this registration purposes, you will use Form LL. So it becomes important when we're drafting the different bonds as to the form that is provided for in the Act, that we follow that when we are drafting our notarial bonds. All right. To make a surety fully liable for the principal debt, it's important to describe him as a co-principal debtor. Also, for examination purposes, if you get to a surety bond, remember when you are describing or citing the parties, especially your third, then that you make reference to the fact that they will be known as a co-principal debtor in your transaction. Then another notarial bond that we get is an indemnity bond. So the indemnity bond is usually the bond by your principal debtor. So we go back to the same mortgagor and mortgagee. But in this instance, your principal debtor indemnifies the surety now in respect of that surety bond against the creditor of the mortgagor. All right. So he indemnifies the third party then. This bond can be described as a bond passed by the principal debtor in favor of the surety who carries suretyship for the payment of an overdraft facility or debt of the principal debtor to a creditor. The kinderbewys is a difficult one because it's granted by the surviving parent who has taken over his estate in terms of Section 38 of the Administration of Estates Act. So this just means that I am giving security or taking out security for the good administration of the funds that is to the benefit of the minor. So the master makes sure then if I take out this kinderbewys that there is adequate security for the good administration that needs to happen so that the minor gets the benefit of such administration. 4.7 is for notarial debenture bonds, which in Afrikaans is the skuldbriefverband. It's a bond granted by a company as security for debentures issued by the company. All right. So this is a company related bond, whereas the previous ones were more relating to the individual or a natural person. This one is definitely more for security for a company. Then one of the definitions that we have to have a look at is the pledge. They say that the pledge of movable property requires delivery of a movable asset that was pledged. And then upon delivery of that movable asset, the mortgagee acquires a real right of security in the movable asset of the debtor. And then once again, remember that real rights can also be registered at the deeds office. Therefore, if you acquire a real right, those real rights can be registered at the deeds office. All right. On the other hand, a notarial bond does not require the delivery of a movable asset hypothecated thereunder, and therefore it is not a pledge per se. So one has to distinguish what happens with a pledge and what happens in the instance of a notarial bond. All right. Fine line on the distinction. Common law says that the mortgagee of a notarial bond doesn't have any real rights of security in respect of movable property hypothecated unless such movable property is in his possession. All right, which makes it difficult then where you are trading with certain movable property, then you cannot continue trading. And therefore, you have to actually give quite good consideration how this condition in your notarial deed will be drafted. So a notarial bond only has relevance upon the insolvency of a mortgagor in respect of the assets subject to the notarial bond, which are in his insolvent estate at the time. Right? So it has to be in your possession and in your estate at the time to be applicable under insolvency. Have a look with regard to the Security of Movable Property Act. So we are in this module busy with notarial bonds. Notarial bonds usually registered over movables. All right. Therefore, we have to have a look at what the Security of the Movable Property Act says, having regard to Section 1 of that specific act, making provision for a notarial bond, hypothecating corporal movable property specified and described in the bond in a manner which renders it readily recognizable, is registered after the commencement of this act in accordance with the Deeds Registries Act, and then such property shall be subject to any encumbrance resting upon it on the date of registration of the bond, notwithstanding the fact that it has not been delivered to the mortgagee but deemed to have been pledged to the mortgagee as effectively or effectually as it had expressly been pledged and delivered to the mortgagee. Right? So there's a lot of assumption made with regard to security of movable properties with notarial bonds that we're registering, and the assumption of that pledge and that it is within your property. All right, so possession is not necessarily, or the property that is so mortgaged is not necessarily then in your possession. All right. It does, however, put you on equal footing with that of a pledgee. Remember, on date of registration, after notarial deed of notarial bond in the deeds registry, the mortgagor requires a real right of security of the corporal movable property as specified and described in that bond. So important, date of registration then in the deeds office and not date of attestation. One has to distinguish the different times applicable to when we are registering or attesting the notarial bond, when we are using it also in other deeds offices. They also make mention what corporal movable property looks like, that it can be recognized, can be trucks, must be described so that it can be easily identified. All right. So it's all about identification. Now, usually when we are drafting notarial deeds, we put in as much description of our movables as possible, so that, and we even go as far to take pictures of those movable properties that we are putting under, or that we are hypothecating under this bond. So usually some of my clients go out and they actually take photos of the trucks that we are hypothecating under these notarial bonds. However, the owner need not be the owner's debtor or be the debtor, because he may be acting as a surety for the principal debtor. So there's different ways that we can structure this, the security that's given for the different principal debtors. And remember, this is where the different types of bonds then comes in, and you have to make a choice as to what type of bonds fits then in with your client's needs at this special moment when you are doing your notarial bond. Is it an ordinary one? Is it a covering bond? Is there collateral required to make sure that your security will be in place? Do you need a third party to give surety for the obligation for somebody else? So that is the choice then that you have to make with regard to the different types of notarial bonds that can be applicable to your situation. Remember the 7 of them, and then you can have a look at your page 187 with regard to the different types of bonds and the definitions that goes with them for easy reference when you are drafting or writing exam. All right. Also, make a note of the authority usually of the company, if it's, not necessarily a minor, somebody under curatorship, whether they can and cannot. What do you need from them if it's a closed corporation? The type of documentation, the original resolution or a certified copy of a resolution that's usually required, authorizing the person to sign documents on behalf of that company. Competency becomes important when we are executing these documents. Also having regard that as the notary, certain documents have to be filed in your minute, and then you have to actually keep a record of it in your protocol. Always remember, this work is definitely for the notary or set aside for the notary and executed by the notary. So all of these other documents or the formalities with regard to being a notary should be kept in mind when you are drafting the documents, registering them. Don't forget about your protocol. It has to be put in the register. The minute the documents that has to be filed in your minute. They do ask a question or so as to documents that needs to go into your minute usually. So if a bond is passed by two or more mortgagors as principal debtors, they are binding themselves usually jointly and separately so that your creditors are adequately assured that they can recover whatever security or financing that they are delivering. Section 80 of the Insolvency Act do not apply to notarial bonds. All right, listen carefully. Section 80 of the Insolvency Act do not apply to notarial bonds, as it only deals with immovable property, but notarial bonds deals with movables. That's the greater distinction of it all. All right. Section 80 of the Insolvency Act, very important. Then we get back to the marriages in community of property. We are dealing or working with movables. Um, we need the consent of that other spouse, usually in writing. It is not specified in the Matrimonial Property Act as to the form of consent. However, as a notary, it is suggested that you do get a written consent, um, that you have something in your minutes to know that you have been authorized duly to act and to execute that notarial bond. All right, very important. Then we get to that recital, the cause of death. So when we think of notarial bonds, we think of the preamble. This is where we start our document that we are going to register in the deeds office. Who's the notary? The party citation is really important as to who is appearing, who is actually granting you authority, who's the lessor and the lessee, and then the property that we are hypothecating there under. So in this instance, we need to familiarize ourselves with the various citations of the parties that we are or that we are describing in our deed, and then the property. Remember that has to comply with the Deeds Registries Act for registration purposes. Then we get to the course of action or the recital in the bond. There has to be an acknowledgement and a cause of debt. Now, usually people forget that they have to acknowledge that there is a debt. It's the same with donations where I accept the donation. In this instance, I have to acknowledge the clause of the debt or acknowledgement of the debt in a clause. And then why am I doing so? So this is really the why of our document is why am I creating a notarial bond? So those two things are really important. Then we can have a look at the lease, and you can see or page 193, the example or on your assignment that we had there, you can see as to what that would look like as to how you would structure the preamble and your acknowledgement as well as the start to your course of debt. All right. The course of debt clause should consist of an amount and the course of the debt, and the amount secured by the bond must be a definite amount. We cannot just say it will be for a amount or an amount that will be created in future or amounts that we will borrow. So that's the one thing. We have to have certain amounts specified either in general or specifically. You have to make mention of that. Then the goods under notarial bond must be also described in general or specified, as it will make a huge difference to the mortgagor's position when it gets to preference in insolvency. All right, very important. Once again, when we get to notarial bonds, the Insolvency Act is something that we always have to keep in mind when drafting. especially with the clauses that we can and cannot put in. And then in terms of the Insolvency Act, the reference made to Section 95, where they say the proceeds of the Act or proceeds of the movable property, which was specifically bonded at the time of the mortgageor's insolvency, may be realized to satisfy the mortgagee's claim. All right. So that is just the working of the Insolvency Act with regard to notarial bonds that has been registered against that movable property. So the mortgagee of a special notarial bond enjoys a preferential claim in the case of insolvency, and the other creditors of the mortgagor cannot attach the specific corporal movable assets. All right. So this is very important, and that's why when you are drafting a specific notarial bond is also the one that we prefer because of the it's favorable when we get to insolvency for our mortgagor. All right, very important with regard to that. Then we get to the Security Movable Property Act again, that has the effect of excluding the operation of the landlord's tacit hypothec in respect of the movable property, especially mortgaged. Right, so we have two acts that we have to keep in mind when we are dealing with notarial bonds. On the one hand, the Insolvency Act, and then on the other side, the Security of Movable Property Act, which have the different clauses and different applicabilities in terms of the Act. All right. Then, in case of a mortgagor's insolvency, the mortgagee only acquires a preferential claim in respect of the free residue of the insolvent estate. All right. This is the only way in which such mortgage can acquire a real right of security in the property of the mortgagor, and then you take possession of it. So delivery then becomes important of the asset if you want a preferential claim in respect of the free residue. Then also remember, where the bond is not lodged within 2 months after the debt has been incurred, the mortgagee will not be entitled to a preferential claim should that mortgagor be declared insolvent within 6 months after lodgement. So once again, when we get to law of insolvency and notarial bonds, time frames becomes important. You have to lodge that bond within 2 months. Within 3 months, it says that you have to register that. But in terms of the law of insolvency, it's 2 months after the debt was incurred. The mortgagee will not be entitled to a preferential claim should the mortgagor be declared insolvent within 6 months thereafter. So if you are acting on behalf of the bank, that clause would be really important to you to know whether you, when this person is declared insolvent, you will have your preferential claim or not. Then we're looking at ordinary and special bonds again. It just says that Regulation 3043 of the Deeds Registry Act is not applicable. In other words, there's no preparation clause. And you'll see when you look at the examples that was given, you start halfway down, there is really no preparation clause. You start with your protocol number, notarial deed, and then you start with your documents. So no compliance with that prepping clause. Then the preamble, like I said, if you can have that specific paragraph in mind when drafting, then that will take you a far way already when you start, because that'll give you certainty. Always remember that the parties executing the document must be qualified and competent. All right. If they have to assist one another when they're married in community of property, you have to cite them as such. When you are dealing with a covering notary bond, you must remember that the owner must disclose the amount beyond which the future debts may not be secured. In other words, we're putting a limit on that amount that we are putting in our deed. The cause of debt will include two amounts. Usually it's a capital and an additional amount. Like I said to you previously, in most bonds you'll find that we are securing for, say, 500,000 and then that additional amount, all right, in the your deed that you are registering, your notarial bond. So the cause of death must not arise from an illegal transaction, and it must be legal and physically possible, all right, to be valid and legally enforceable. A notarial bond may secure more than one cause of death, bearing in mind Section 50, subsection 5 of the Deeds Registries Act, and then more than one mortgagee is always possible, depending on your circumstances. Have a look at the causes of death for most of the notarial bonds. Just remember, the wording is usually important. Say, for instance, money is lent in advance, plus that additional part of your sentence that you need to add to this usually. So to actually give effect to the type of bond that you are trying to register. Very, very important. So I'm referring you to page 187 in this instance. So you'll see if you do an ordinary bond, then you'll see the causal on the far right hand side that says that you have to be truly and lawfully indebted to and on behalf of the creditor in the sum of what amount, being monies lent at advance by the mortgagee to the mortgagor, capital amount, and then if money due and owing, to be truly being money due and owing by the mortgagor to the mortgagee. All right. So those causas you can really learn off by heart, because that'll give effect to the type of bond that you are trying to then draft in the exam. So those causa is type specific to the bond that you are trying to register. You cannot use the same causa, for instance, to a continuing covering bond, because it's the specific causa for a covering bond will be, and to be advanced is the difference that you will state within the citation or the causa clause of your bond that you are registering. So page 187 is important when we get to the types of bonds and the causa that really ties in with the bond that you are trying to register. All right. Any questions with regard to page 187 and the different clauses? Simon Gilly, you'll have to give me a chance. 170. Thanks, Nicole. I appreciate that. All right. So, yeah. So have a look with regard to the causes for debt, the citation of the causa that you put in your different bonds that goes with it. So the cause of debt is set out nicely there, but I just find that if you do see it or oversee it within page 187, you get a better idea of the inclusions in your different types of bonds that is necessary to distinguish as to what you are busy with or your drafting skill. Yeah. I'm just trying to read this. Yes, obviously, if you are encroaching on government property, you'll have to get consent for that. Alternatively, does the lease agreement the owner of the movement from the state government not register? Yeah, usually, upon we're trying to register, usually the government has no insight into bonds that we are registering. Notarial bonds usually, or well, we go back to notarial leases. There we have mineral rights that we will be registering, but as such, it's deemed to be immovable property, and you will register a mortgage bond. But that is in a different, it's in a different deed that you are registering. So just be careful not to mix the two. I know it seems the same, the notarial bonds and the leases. Just keep the two apart, because I can already see a mixture of in your question that you are asking. All right. All right. So if there's any questions on the causes of the debt. I am going to page 180 now for security under your bond. I'll pause over 187 just now again with regard to the different causa that you can use for the different types of bonds. So the security that we give under it must be described in the bond. It can be either general or special, like we've previously noted. So that's the type of security that you're giving, and it is described by virtue of the causa usually. That gives an indication where we are heading, and the heading as such of the bond is not the indication of the content of the bond that you are trying to register. Then there's miscellaneous conditions that you can put into your bond. You'll see that there's a few of these conditions um, that is not really considered anymore or taken or put down into a contract. One, because it's considered pro non scripto, or it is just a matter that the courts find it unduly oppressive and therefore not enforceable. So try and stay away from those clauses that is not usually used in contracts. But let's just go through them quickly. So you get a pactum commissorium, lex commissoria. It's an agreement that provides that on failure of the mortgagor to comply with the terms of the bond, that it just forfeits the property. Now, a court doesn't really want to do forfeiture of property of any of your belongings anymore, and that's why they then say that you shouldn't. It's not enforceable. The next condition, parate exequi, is a provision that may be made for the mortgagee on default by the mortgagor to sell the mortgage property without recourse to law, i.e., a court order. However, the mortgagor must, following his default, give consent to the execution with a court order. Otherwise, the execution cannot be affected. It's not really effective because if the one party then defaults, I don't think they'll give you consent to execute against the property. So think carefully about, unless you get the consent while all the parties are still happy with what you are busy with in registering the mortgage bond. The impartiality of the notary is also made mention of. The specificate of Estate Brown is where a notary or a bond was registered in favor of the firm where the notary was part of or member of the firm, and that bond was then found or said it was null and void because of the impartiality that's expected of the notary. Just have a look at that judgment in that matter. The ranking of a notarial bond. So remember the difference again when we are registering mortgage bonds to notarial bonds. When we are registering mortgage bonds, then we'll make provision for the ranking. In other words, your first bond will be stating we're registering a first bond over the property X, Y, and Z. And then if there's a further bond to be registered, it will be a second ranking that we'll make reference to. We don't make reference to the ranking within the registration of notarial bonds because it will obviously will be obvious from your date of registration as to when the debt came into existence. So date of registration then becomes important, and it's important then that you register usually as fast as possible to make sure that you get the best benefit for your creditor in the matter. Okay, they just make note there that it's not the date from when the debt came to in existence. It's always date of registration that's important. And that's why your preamble becomes important for that date. No blank spaces in that preamble. Deed office in any event will raise the note if there's any blanks that needs to be filled in. If two notarial bonds are executed on the same day, then the ranking lots in each bond will be ranked at the same level. So they will be of equal ranking, no benefit or preference to the one to the other, all right, because it will be at the same time. We have to have regard to the Insolvency Act. Remember, we are dealing with movables in this instance. Richard, I just want to read your question quickly. Yeah, so what happens with the Insolvency Act with regard to immovable and movable property it's in the furtherance of the business and usually with possession that was given or the deemed delivery of certain of the goods. So that is the assumption that is made under the Act of what is in possession of the mortgagee or the creditor at that stage. And that is then where Section 80 then becomes integral part as to the deemed property or possession at the time, although delivery had not taken place, and what falls within the insolvent estate and what not, and what is part of that insolvent estate. That's where Section 80 of the insolvent estate becomes important. Yeah. Usually when we're dealing with this, remember, with some of the registration, say for instance, of certain of the notarial bonds, the assumption is always, well, let's go one step back. When we have leases, that's registered a notarial lease. A long lease will be considered to be movable property. Yes, and that falls there under. So we must have a look as to where the Insolvency Act finds applicability, whether it's a long lease, because I think a lot of these questions, because the notarial lease and the notarial bond is not separated. All right. But yeah, we can have this conversation a bit later on if you don't mind. All right. Then, yeah. So I'm still busy with the Insolvency Act that's creating headaches for most of us. So Provision 86 of the Insolvency Act, no notarial bond registered after the given date shall give any preference whatsoever over immovable property. All right. So immovable property is always the stronger right that we have. We get the Security of Movable Property Act that changed the position of the mortgagee in the case of insolvency. All right. Radically in other provinces, excluding Natal. And when we read this, Natal is always the exception to the rule when we get to notarial bonds. Right. Richard, I'll also go back to 8.4 then for that quotation of Section 8 to see the working of this specific one. A special notarial bond registered after the commencement of the above-mentioned Act, according to Section 1, is deemed to have been pledged to the mortgagee as if expressly pledged and delivered. So remember the difference here is the delivery of it. So it's a deemed delivery that we have, and that we have possession of that specific movables. All right. So this is the distinguishing fact. And remember also with notarial bonds, we specify usually the movables that we are binding under that contract so that we can get that preferential ranking or the claim in terms of the Insolvency Act. That's why the drafting then becomes important with having regard to this. So let's have a look at section 1.3 and 1.4 that says that the provisions of subsection 4, a notarial bond contemplated in subsection 1, other than a notarial bond contemplated in section 1 of notarial bonds, the Natal Act, which was registered before the commencement of the Act, shall upon insolvency of the mortgagor before such commencement confer on the mortgagee the same preference in respect of the entire free residue of the insolvent estate as that conferred in the mortgagee by a general bond in terms of section 102 of the Insolvency Act. All right. So it has to do with registration of your notarial bond. Okay, so always the registration of your notarial bond that we have to have a look at. Subsection 1.3. Subsection 1.4 says the provision of the subsection 3 shall not apply if any part of such free residue was before the commencement of this Act paid out to concurrent creditors in terms of the confirmed account. So the Insolvency Act really has to be kept in mind when we are drafting notarial bonds as to the inclusion of specified property that we are binding under this specific bond. So be it cattle, or we on a dairy farm and you have to count the cows or the marked cows, it's important under those notarial deeds that it is very specific and that it's identifiable because of the effect that insolvency may or may not have on that specifically, or the preferential claim that is created by virtue of being specific in your notarial bond. Whereas if you just basically generally state that you are binding all the cattle on the farm, then you don't have that big of impact with the registration of your notarial bond. So be as specific as you can be. And that is what they say. If the general bond makes provision, the mortgagee can, by court order, or attach the mortgagee's movables. But once again, the general notarial bond is difficult because you don't really know where to draw the line as to what and what you cannot attach in the instance of insolvency, right? And all of these things really is used to secure the asset under the bonds. All right, then candidates should know the provisions and importance of Section 88 of the Insolvency Act. For me, the Insolvency Act is just important straight through notarial bonds. Be it the different sections, yeah, it is really important to know the working of the Insolvency Act when we are working with notarial bonds. It has a far-reaching consequence. But let's see, Section 88 specifies that a mortgage bond, other than a Kustingsbrief, whether special or general, passed for the purpose of securing the payment of debt not previously necessary in every bond, which is not for a loan of money. In other words, a bond to secure the balance of a purchase price. All right. So important this. The exception may no longer be renounced in a bond. Right. So this is also part then of the renunciations that we can and cannot put into our. Sorry, guys, I just missed something there now. So we're still busy with the renunciation clauses in the notarial bonds and what we can and cannot put into the clauses and what we should consider to avoid when we get to insolvency and we cannot attach or we cannot describe or identify the provisions. Well, we identify the products that are under the notarial or bound under the notarial bond. All right. They say that provisional sentence can be granted on all notarial bonds except covering bonds. So that is the alternative to issuing summons, that you can apply for provisional sentence summons when you have a notarial bond. So that is something that's beneficial. You can, however, not substitute a debtor under Section 57 of the Deeds Registries Act, which applies to mortgage bonds and not notarial bonds. So when you want to substitute a debtor under a notarial bond, you'll have to cancel and you'll have to pass a new notarial bond if you want to have a new debtor that takes responsibility or takes over the liability of the existing bond. Then we get to the exceptions and the effect of renunciation thereof. So now previously we've dealt with all the miscellaneous clauses that we usually find within the notarial bond that we can make provision for. And what we find is beneficial to clients to have in a bond. Remember, we are securing debt that we want to be able to collect at some stage if there is any defaulting party. Then we get that exceptions and renunciation of certain of the benefits that you can get. And once again, have a look at the National Credit Act. So for purposes of notarial bonds, Deeds Registries Act really important. Then you go on to Insolvency Act, and then the Movable Security or the Movable Security Act, and then we move on to the National Credit Act. So Section 32, in terms of certain exceptions are always available to mortgagors and may no longer just be renounced if the said bond falls within the ambit and scope of the Act. So very, very important that we know what the boundaries and ambit of the national credit allows for and what not, because that's something that a lot of people struggle with in practice as to the applicability of the NCA. The exceptions that usually we get in the notarial bonds, the fact that we find them there does not mean that they are worthy of being there. And you'll see that the first one, for instance, exception, non numeratae pecuniae, this exception may no longer be renounced in a bond which falls within the ambit of the NCA. This just means that previously a mortgagor could renounce this exception in the case of a bond to secure monies lent in advance. The benefits of this exceptions, that if you were sued, you could plead that notwithstanding the acknowledgement that the money was not actually paid to you, and therefore you're not responsible or liable in that instance, right? So yeah, it's no longer available. You cannot use it because it does. It falls within the ambit of the NCA Act. The NCA will rule in this instance. The next exception, what you can usually or see in the notarial bond, exception non causa debiti. By raising this exception, the mortgagor can plead that there was no cause of debit or debt for the obligation, and the renunciation of the benefit of this exception is necessary, which is not for a loan of money. Right. They also say that because it falls within the ambit of the NCA, you're no longer supposed to be using this when you are drafting a notarial deed. Very important thing. All right, and the next one also, the revision of accounts and errors of calculation. Usually you can, the debtor could say that there was error in the element of bookkeeping or accounting, and that the benefit of the exception applicable to the bond for goods sold and delivered, and also to building bonds where the capital was paid over in installments, and also on covering bonds. 3 exceptions no longer be renounced in the bond because the NCA is applicable. All right. So the first 3 falls within the ambit of the NCA and therefore not applicable anymore. Then we get to the beneficium dadaobus val pluribus res debendi, where there's more than one mortgagor, they are jointly and severally liable for debt. All right. So any of the debtors can be sued for the full amount of the debt, with the exception has not been renounced. A joint debtor is only liable for his pro rata share in the matter. All right. Have a look at equitable fire assurance. Versus Solomon, quite an impressive judgment. This exception may still be validly renounced in all bonds and is usually renounced in bonds passed by 2 or more mortgagors, because they can say that you have not, you haven't used all the avenues to recover your debt. So that one you may still use. Beneficium ordinis sui executionis. It's an exception open to a surety. Remember, a surety is for a third party, which can be compelled, or you can compel the creditor to proceed against the principal debtor first and obtain all he can from such debtor's estate before proceeding against the surety. So that exception is still used and can be renounced and used in security bonds. So this is definitely an exception that we can have renounced in a notarial bond. Beneficium divisionis. It provides that the liability under a suretyship must be apportioned among the sureties and each cannot be sued for more than his pro rata share. So it's a matter of equally, or basically executing in equal shares against the debtors or the sureties then for this. All right. That is that one there. The exception also may be validly renounced and is used in surety bonds. And then you can also plead that no value received, and it should be renounced where the obligation relates to an account for goods sold and delivered. But you'll see that most of these exceptions is raised with regard to goods sold and delivered. All right, so that's exceptions. So what have we been dealing with? We've been dealing with clauses that we usually find within a notarial bond that is registered and its applicability thereof. Then we'll usually find an interest clause. In other words, we won't only make provision for the capital and an additional amount, also with regard to any interest that may be charged. Just be careful whether the NCA is applicable or not, and whether you have adhered to the conditions to be a credit provider in terms of the NCA when charging any interest in your notarial bond. So one must have careful consideration with regard to this interest clause. You can't just include it. It can have detrimental impact on your clauses or penalty clauses as such, because that's what it's used for. The repayment of capital. How will the capital be repaid? In installments or otherwise lump sum? And what is the place usually for replace, or where you have to repay the capital? Use the bank account. If you look at your documents, we don't really go and make the payment in a bank or to somebody specific, seeing that checks is not really, it's not used anymore. Insurance. It's a clause that's usually requiring to insure the mortgage good as its cost. Remember, we're taking or giving security for that. It will be in everybody's, or to everybody's benefit, should insurance be taken out, especially if you think about cattle that can die in the field and veld, depending on the circumstances, and then you need insurance to cover for that eventuality to secure your mortgage good that you have so bounded under the notarial bond. Who pays for the registration of the notarial bond? Usually it's paid by the mortgagor, the one that gets the benefit of the notarial bond. Statements of amounts due or indefinite proof of indebtedness. This just says as to how to go about to determine the state of the debt when you are executing against the notarial deed. So it says that provision can be made with a certificate signed by the mortgagee or his representative, and that will serve as prima facie proof of the indebtedness of the mortgagor for purposes of obtaining a provisional sentence against a mortgagor. So this is the preferential way of dealing with default, is obtaining a provisional sentence with your notarial bond that was registered. Obviously, we also make provision for the domicilium standi of the mortgage, or where do we serve papers if there's any default, or we have to give notice, say, for instance, in a bank account or payment or place of payment that has to be made. Then a cost clause or additional clause, depends on how you structure it, how you will set those aside. Usually the cost clause is also set with the capital clause. So those two clauses goes hand in hand. Foreclosures, also important, is to enable a mortgagee to call up on the bond by default of a mortgagor. And we only realize the benefit of this clause if somebody has defaulted and to the drafting skills, because then it's when we find that we cannot execute because this clause is not available in our notarial bond. So this is one of the clauses that I would strongly suggest that you have in any notarial deed, is a foreclosure clause, and make sure that it's actually executable in the different scenarios that you can think of. Continue and covering security. You can provide for the cover for future advances or goods to be sold and delivered where it's necessary. That could be for a covering bond, depending on what your type of service maybe, or the goods and that you are delivering maybe. Restraining alienation clauses saying that you cannot sell the goods unless it's in the ordinary course of your business, obviously. Right of access. Usually this is the mortgagee's right to have access to the mortgagee's books of account in the case of a public trader, but it's also when you have to go and inspect, say for instance, this cattle that has been secured by virtue of mortgage or by a notarial bond. You'll go and you'll investigate and see how many cows is left and what is the extent or what's still covered by your notarial bond, the right of access. Restriction of further bonds. Remember, for every bond that you are registering, you are diminishing your right when you have to execute. So a clause restricting further bonds is also something that we find necessary. You don't want to diminish your right that you have to execute. Court of jurisdiction. Usually, the agreement makes provision for a magistrate's court that have jurisdiction for purposes of the bond. Not necessary, but people do that because it has become habit, really, when we practice. Payment of rates and taxes. It's confirmed in bonded leases, or it's confined to that. Cessions of rents to a mortgagee, also confined to bonded leases. And this is now where your line between your notarial lease and your notarial bond, you really have to make the distinction as what you are busy with. Am I busy with a notarial lease? Have I done or complied with the essentials with regard to that type of document? Whether I'm dealing with my notarial bond. Really don't try and I see a lot of confusion with regard to the two sets of documents. Try and stick to, when you're doing a notarial bond, this is what I'm busy with. This is the clauses that goes into that specific one. And then obviously there's a general clause like in every other contract where you specify the movables that can be included as long as it's a corporal movable, furniture, livestock, vehicles, stock in trade, for instance, trucks, if you're in the selling business of trucks, incorporeal movables, unregistered leases. And please read the case of Smith versus Farrelly's trustee. And then there's the one of Wilson as well. A registered land settlement lease with an option to purchase, which has been exercised. Once again, look at the Natal matters with regard to the 99 years sugar leases in Natal, where they suggest that you should read Fusline, where the court held that in the case of a sugar lease, the lessee had entered into an agreement with the lessor to purchase the property in the document called endorsement of lease, which expressly provided the lease was to continue in force, and the safest way to register the pledge of the lessee's rights would be to pass a mortgage bond over the lease and a collateral notarial bond over the endorsement of lease. So here is a mixture of what I've been talking about. So try and keep the two separate, otherwise there will be confusion when you try to register the notarial bond and you have a notarial lease with a specific pledge in mind. And then usually they try and confuse you with Natals. They will give you a whole scenario with regard to something that's happening or a lease in Natal, and as to the mortgage bond that you can and cannot register. All right, and remember when we get to long leases, we deal with mortgage bonds as well, depending on whether it's deemed immovable or not. Have a look at legal licenses. You can also mortgage or put into a notarial bond or use a legal license for that purpose. The nature of a legal license today, in terms of the latest legislation and regulations, do not permit the transfer of a legal license because it's really address bound as well. So your compliance here with the Act has just become so much more strict, and therefore it's not a transferable right anymore. So it's just really so that you know that was done previously, but not allowed, because you'll get clients that said, but we used to take our liquor license and register notarial deeds over or notarial bonds over liquor licenses. Goodwill of business is also conceived as a incorporeal movable that can have a notarial bond registered over. Shares in a company, rights of succession to a deceased person. That's a difficult one if you want to venture onto a notarial bond for that type of rights. Rights in movable buildings and a site permit can be also used as the product of it. Motor carrier certificates, claim licenses, and gold law. Remember, when we are dealing with the registrable leases, mineral rights has to be kept in mind, and then book debts, and then registered short leases. All right, are all registrable under notarial bonds, or they can all be used for purposes of the registration of a notarial bond. Then I'll just quickly go through page 187, which is really your best reference guide to what notarial bonds is about. Quickly, ordinary bond. What is your legal exception that you can use or not use? Non-numeric tie pecuniary or non-causa debiti. Continuing covering bonds. What is it used for? Bond to secure present or future obligations and future obligations. Then you have your legal exceptions that you can use in that instance. Collateral bonds, which is an additional security or collateral for another registered bond. Remember, it's used for an existing, so you have a registration that's already taking place. So there's something already that is used as security. The surety bonds, remember that's the third party that gets involved now to stand surety on behalf of another, your debtor. I haven't given attention to your debenture bonds. So if you look at page 188 again, same thing there. Kinderbewyse, a bond in favor of the master to release minor's assets from the guardian's fund. Remember, when children inherit money, then it's usually placed with the guardian's fund for when they get older. But you can take out the kinderbewijs or register one so that you can get the benefit of the release of those funds. Yes, so that's also your form of a notarial bond, is a kinderbewijs. Debenture bonds, like I said previously, for the use by companies to secure indebtedness by companies. Very important. See Annexure 8A to 10, just so you can see how it's used and how those clauses look. Then there's the bottom bonds that you get to secure a loan advance on the security of a ship. So that's something different, but that's on module 10 that will deal with that in depth. And then respondentia bonds also to secure loans advance on the security of cargo, which is also important when you are in the transporting business or importing, exporting business, where you have to secure your movables that is conveyed in that manner, either by ship or by land and seen as cargo. Then we get to the waiver of preference of a usufruct. Here, once again, we're looking at the different types of ownership and also, so when we get to usufructs, we must keep in mind that there's a bare dominium owner. Usufruct, usually that this is where a fixed property subject to a usufruct offered as security and the usufructuary does not join as the mortgagor. He has to waive his preference of right when you do want to take out or register a notarial bond. What does this mean? It means that I have a granny that has the use and enjoyment of certain fruits. Now we are basically registering a notarial bond over movables. Let me take another instance like furniture. But if I do that, then I take away some of the rights that she has. So unless I join her as one of the parties, she has to say that I will not have any preferent claim in this. Remember, it's a personal servitude that has been registered and it is attached to her person by waiver of preference. And in that instance, you'll get a written consent to register a notarial bond with that in mind. So it applies to all holders of rights of usus and habitatio. And while the mortgagor complies with its obligations of rights of the usufructuary, he remains unaffected. All right. So you just have to distinguish as to when the holder of certain rights, what happens. So the bene veniam owner can enter into a notarial bond with the waiver of preference obtained from the usufruct. It's advisable from the bondholder to obtain a special power of attorney from the usufructuary when the waiver is signed, enabling him to cede the usufruct to the purchaser of the bene veniam in the event of sales and execution. That's what I described to you earlier tonight. When people default, we're selling the property usually at sale at execution, and then the sheriff will say we're selling it subject to whatever rights there is registered against that title deed. And then one of the endorsements usually can be for a usufruct or personal right as described in this. And then we have to deal with those personal rights that has been created and to get hold or to basically release the property from that. Nobody wants to buy a property that's encumbered. This is one way to do this so that you can actually sell it. Otherwise, the huurgehad verkoop will also find most likely benefit in the same, or you'll approach it in the same manner, is that you will try and sell your property without that encumbrance, either of the usufruct of a lease agreement attached to that property or the endorsement. So a specimen of the notarial waiver is also attached then in your annexes to this notes. If you can have a look at that. Please just practice your waiver of preference of your usufruct. Yeah, make sure, yeah, the heading is not really that important, but it does give direction as to the content that you are busy with. Then there's various actions that you can take with regard to notarial bonds. You can cancel it. Format is important when we are canceling a notarial bond. Remember, it was created notarially by virtue of execution. You have to cancel it in the same manner. Form MM of the regulations of the Deeds Registry Act, and it must be signed by the mortgagee. So if you cancel it in the same manner that you basically created it. Then the release of the property or person. You can also get that you're releasing a person from the bond, and then a consent must be prepared in accordance with Form MM and must be signed by the mortgagee. If there's one or more mortgagors over the property, both of them will have to sign the documents. All right. The noting of a part payment. Once again, this takes away from the indebtedness, and it has to follow the format in what the deeds office prescription is set out. You cannot have it endorsed, or the deeds office will not allow for that endorsement if the format is not correctly adhered to. So very important, you have to practice your Form MM. What was it now? Form KK, LL, and MM for tonight's subject that we've dealt with, so that you know how to deal with the release or the citation with regard to the consent that needs to be obtained to release, the noting of a part payment, what type of document is required, what does it look like, these type of clauses you'll have to be able to draft. All right, noting of a part payment. This is where a mortgagor has paid part of his debt. An endorsement of part payment can be made on the bond, and that's the effect that the amount secured in terms of the bond is reduced. And that it just shows that it has already been paid. It's not really often used these days. It's mere a fact that people cancel the notarial bonds once it has been exhausted or the security is no longer needed. But you do find that people want, if they have paid it, they want the reduction or the noting of the part payment. Then also reduction in cover. Also, the reduction is also by virtue of endorsement made on the bond, also done in terms of the consent form prescribed in Form MM, signed by the mortgagee. Noting part payment and reduction in cover, more or less the same content. It's really just the wording that is different in it. Then the waiver of preference in favor of another notarial bond. Remember what I said, it's determined by the date of registration and not the date at which the debt was incurred. Always very important when you do that waiver of preference. And what is important and how do we note that is from our preamble that we have in our documents or the notarial deeds that we are registering. We can cede our notarial bond. The provisions of Section 3(1)(j) of the Deed Registers Act makes provision for the cession thereof. And here it's important that we note whether it was an out-and-out cession or whether it is a security. Whether out-and-out cession results in a complete transfer of the mortgagee's rights to someone else, this section cannot be cancelled except upon order of court. Remember, out and out, it's gone. It's a complete transfer of your mortgagee's rights. So you basically, it cannot be cancelled. That's the beginning and end of it. It cannot be cancelled. You don't want to bring the order of court even once you've done that, except if it was by error, and then you have to look at your PI. If the notary has been negligent, definitely you'll bring that court order on or the application at your own, you'll pay for it for yourself. When a notarial bond is ceded as security, it is merely a pledge of the bond. In other words, the existing mortgagee retains an interest in a notarial bond, and then when the debt is repaid at some future time and the cause for the cession disappears, the cession may be cancelled. So you only see it meanwhile. It's in between interim arrangement that you're ceding it just as security, and nothing more, nothing less. And this can be cancelled when there's no more debt or the time the session, the causa for the session has disappeared or lapsed. A mortgagor's consent to the cession of the notarial bond is required if the full amount under the bond is still due, irrespective whether it's out and out or whether it's just a security. That signature is required. Just make all sure as to your authority who's signing the sessions, and obviously the competency that goes with it. The mortgagee's consent to the cession of the notarial bond is required if only a portion of the amount owed under the bond is ceded, or the cession results in a number of the mortgagees increasing. Right, so that is where you have the consent necessary for more than just the cession of the mortgage or the notarial bond. All right, then usually also the mortgagor consents in cases lodged at the deeds registry along with the cession. So that would be one of our documents. You'll not only file the form MM, together with that you'll also lodge your mortgagor's consent to the cession that you are drafting or that you are lodging in the deeds office. As I previously said, you cannot substitute the mortgagor when you are dealing with notarial bonds. You have to cancel and you'll have to re-register or register a new notarial bond. Noting of variations in terms of a notarial bond, there's easy 3 marks. The following conditions may not be varied: the cause of debt, the mortgage security, and the amount secured under the bond. If you want to vary any of these, you have to cancel and re-register your notarial bond. All right, and that is my story for tonight. Any questions, please? Like I always say, please just try your hand at the assignments that was given. Just have a look and get a feel for the drafting that's required, and take note of the writer of the notes that was given when dealing with the assignments. Um, yeah, and then usually it gives you the options of all the different clauses that you can put in. And always when drafting in the exams, when we see the headings, we know that you know what the content should be. And then if they ask you to elaborate on some of the conditions or clauses, then obviously that just makes it easier because you'll know what is required or what the content of your um, notarial documents should look like. Is there any other questions at this stage? If there's nothing, then thanks a lot. Unless on what page are you, sir? I know where MMINC is. Great. Anybody else for a question? And then tonight we are well within time. Thanks a lot, everybody. Our next presenter, Litsa Skylarkers, will be presenting next week. I do hope that you find some relevance in what was taught. Yes, and good luck to your exams.